Inuzo versus State. And in the circumstance, the relief one of the counterclaim fails and is dismissed, I so hold. The second relief is a declaration that in the light of the prevailing circumstance of this case, the insistence of the claimant to defendant to counterclaim, particularly having succeeded in citing the second defendant to terminate his employment to continue to maintain the instant action, amounts to bullying, harassment, and unfair labor practice. It has already been decided earlier in this judgment that the failure of the second defendant to immediately terminate the employment of the first defendant upon being notified of the first defendant's obligation to the claimant as provided in clause 23 of the contract of employment dated 1st June 2019 amounts to a contributory breach of the contract of employment by the second defendant. The insistence of the claimant/defendant to the counterclaim in inciting the second defendant to terminate his employment could therefore not amount to bullying, harassment, and unfair labor practice. Relief 2 of the counterclaim fails and is dismissed, I so hold. Relief 3 is for an order restraining the defendant to counterclaim from continuing to intimidate, harass, and or threaten the counterclaimant with any lawsuit and or writing letters to third parties who is willing to engage the counterclaimant in any matter howsoever. Decided in earlier 5 of, as it was decided in Relief 5 of the suit, the contract of agreement provided that the first defendant was restricted from joining a similar business in similar capacity for 2 years after his exit from the claimant company, which ordinarily would have expired in 2022. Judgment is being delivered in 2025. It is my holding that this order's sort is speculative. There's nothing before this court by the counterclaimant to show there is need for a restraining order on the claimant/defendant to the counterclaim. This relief is dismissed and therefore fails, I so hold. Relief 4 is for damages in the sum of 50 million naira against the defendant to counterclaim. Counterclaimant has not adduced evidence to show he has suffered loss from the evaluation of this court. This relief fails and it is dismissed, I so hold. For relief 5, I make no order as to cost. All sums awarded in this judgment is to be paid within 30 days of this judgment, failing which it will attract 10% in simple interest. Judgment is accordingly entered, signed. So this is the judgment of the court.
My Lord, we are most grateful for the well-considered judgment. Even though we had a very interesting trial, which I believe was the most interesting part of this case, my Lord was kind enough to accommodate us. I and my learned colleague, we had our day in court that day, but my Lord was kind enough to accommodate us. And I'm grateful for the judgment of the court.
Okay. You're welcome.
My Lord, we are also very grateful for the judgment of the court, and we commend my Lordship for the decision.
Okay. All right, thank you. So we can leave the meeting now.
Thank you, my Lord.
Okay.